we'll get going, and I really appreciate everyone being here today, and thank you for attending our training on this is Colorado versus Oregon, the Colorado Natural Health Act compared to and contrasting to Oregon psilocybin services. My name is Jason Burge, and I'm the co-founder and chief business officer with the Psilocybin Assisted Therapy Association. We are a national nonprofit, fortunately based out of Portland, Oregon. Our mission is to promote the educated and informed use of psilocybin to address the mental health crisis. We really try to aim to provide best practices and education for seekers, mental health professionals, and guides and facilitators, with all of our focuses being on the seeker's mental health. Really honored today to have Sean McAllister here with McAllister Law, who will be doing the presentation. He is one of the drafters of the Colorado Natural Medicine Health Act, and also a very advocate and knowledgeable about the psychedelic law across the U.S. So thank you, Sean, for being here, and I'll pass over to him in a second. The whole training should last about 30 to 40 minutes, and then we will have an opportunity for Q&A at the end. So with that, I'll welcome Sean, and thank you again for taking the time to be here for all of us.
Jason Burge, thank you so much. Psilocybin Assisted Therapy Association. Nice little turnout here on a Wednesday night. You're in Colorado like me, you're freezing cold right now. So I hope everybody is staying warm. And boy, you've got an interesting sense of humor to sign up for a legal discussion right at the dinner hour. But hope to keep it a little bit lively and really do a lot of interacting. I see a lot of friends and some clients here on the call, and it's nice to see familiar faces. So yeah, I think I want to just start by introducing myself a little bit and saying that, before I'm a drug policy reform lawyer for 25 years, I am a lot of things. I'm a father, a musician, an artist, someone that is deeply engaged in a medicine path. And, I think I'm here, and maybe we're all here because of the transformational power of reverential use of psychedelics. And it certainly has been a hugely important thing in my life. And I would just say that, I've never had mental illness and diagnosed mental illness in my life, but I've been in love with people who've had diagnosed mental illness, and my children have suffered from family mental illness situations. And it really was plant medicine 7 or 8 years ago that helped heal a lot of the trauma that I have from a lifetime of just living in this culture, but also opened up a bigger Pandora's box of the message of these medicines, which is that we have to understand where they come from and respect Indigenous people and be thinking about something more than ourselves and a broader community, and the intersectionality of psychedelics with BIPOC issues, LGBTQ issues, environmental right issues, Indigenous rights, women's rights. Really, a lot of the main things you care about are touched by the ethics of psychedelics. And for me, that has been so inspirational. And so, yes, I'm just another person that was inspired by the transformational power of these things and started shifting my focus in drug policy reform about 8 years ago to psychedelics. Before that, I wrote cannabis legalization with other people in Colorado and spent 12 years as a cannabis and hemp lawyer. Before that, I was a criminal defense lawyer standing next to disproportionately Black and brown defendants facing prison time for the use of controlled substances. So I've had a really blessed career to be involved in the intergenerational struggle to liberate some of these substances from the criminalization and ignorance of the drug war. And I'm really satisfied where we are right now in terms of you're really blessed if you think about the history of human evolution to be living in a time when this old regime is coming down and new opportunities are popping up. So enough soapboxing from me, but before I cover the content, I'm a lawyer. I got to cover a little legal disclaimer that I am going to say a lot of legal things today, but I'm not your lawyer. I'm not talking on behalf of any of my clients, and obviously rules are constantly evolving and changing, so you have to watch out for that. Here's the colonized introduction, all my bona fides, and I've done a lot of things in my career. I mentioned some of them already, but the most important thing in the context of this discussion is just the deep involvement I've had with the Natural Medicine Health Act in Colorado. I'm not an Oregon lawyer. I have studied the system a little bit, and I want to start out by focusing on the main differences between, or maybe some of the similarities. So I'm going to cover that first. But then I'm going to shift into more of a deep dive on the Colorado model and really give you a sense of where things are today. So you guys know the basics, but just in case you don't, Denver was the first city in the nation to decriminalize psilocybin in 2019. I was a legal advisor to the Decrim Denver campaign, and have been involved since the beginning in Colorado around efforts to reform our laws. But then Oakland quickly followed after that. And then, of course, Oregon jumped out in front in 2020 with Measure 109 to create regulated access to psilocybin only. And as you all, there's a lot of Oregon folks on the call know, Oregon also passed Measure 110 in 2020, which decriminalized possession of most all drugs. So there was a lot of excitement in 2020. Oh my gosh, we got regulated psilocybin, we got decrim drugs in Oregon. Unfortunately, that didn't last. As most of you know, Oregon has repealed Measure 110. So we no longer have decriminalized personal possession of controlled substances in Oregon, but we do still have the Oregon Measure 109, which is up and running. And that's maybe the first place to start with. The major difference between Oregon and Colorado is, unfortunately, Oregon lost its decriminalization. Colorado came online in 2022 with Proposition 122. That's a lot of twos. And the point is that we both decriminalized for psychedelics, not just psilocybin. That is psilocybin, DMT, mescaline other than peyote, and iboga. So Colorado is decriminalized for psychedelics, the only place in the nation to do that. For all adults over 21, you can possess, cultivate, and share in limited context. I'm going to talk maybe more about that later. But there's a decriminalization side of the Colorado law that no longer exists in the Oregon law. Even when Oregon had Measure 110, it was not legal to cultivate or distribute mushrooms or any other drug. So that's very different about Colorado. We actually have a very robust, broad decriminalization with no personal possession limits on. It says you can have a personal possession amount of those 4 psychedelics in the decrim world. And so this is a major difference between the two states right now, that anywhere in Colorado I can grow, possess, and share psilocybin. I can't do that in Oregon legally. The only way in Oregon legally to get psilocybin is at a service center. So that's a major difference. Now, the thing we have in common, we both created these regulated access programs. Oregon calls them service centers. Colorado calls them healing centers. So basically, different names, same idea. You go to a service center in Oregon or to a healing center in Colorado. You do a prep, administration, and integration session. All the administration sessions are all in the licensed facility. You don't take anything home. There's no extra that goes home. There's no dispensary model in both states. So that part is exactly the same. There's no off-site consumption of state-regulated psilocybin in Oregon or in Colorado. That's the same. There is the ability to have outdoor administration in Oregon and in Colorado. So there's something that's similar. You can go to a healing center in Colorado. It can have an outdoor area that's contained. It has some protections. Same thing in Oregon. You can go to a service center and have an outdoor experience. One of the things that's very different, though, between Oregon and Colorado is, again, we're very lucky because we learned some of the lessons from Oregon. So in Oregon, you can only do administration sessions in service centers. In Colorado, we have in-home administration allowed. But I see the claps from Laurel, but the drafters, we envisioned a much broader in-home administration system than what we got out of the regulations. So unfortunately, the regulators have said you can do in-home administration, but only in a very narrow context. When somebody has palliative care situation where they're homebound, when a doctor says it's against their medical best interest to go to a healing center, be outside of their home, there's some very limited context that we can do in-home administration in the regulated model in Colorado, but there is a pathway. And you also have to have, I think, 1 year of experience in Colorado doing administration sessions and 100 hours of administration before you can do in-home administration. So this is a big deal for end-of-life palliative care people that Oregon left out of the mix. And so, but it doesn't look like in Colorado we'll be able to do this in-home administration for about a year because it's going to take that long to get the experience. So that's a big difference in home administration. Like I said, I'm just starting with kind of some similarities and differences, and then I'm going to do a much deeper dive into the Colorado system to give you a sense of where we are. But other differences, there's similarities in the training requirements, but there are differences. Oregon only requires 120 hours of training and 40 hours of practicum to be licensed as a facilitator. Let's see, as I understand it, you have one type of facilitator license in Oregon. You're either a facilitator or you're not, and you meet those standards. In Colorado, it's similar training requirements, but it's a little more. It's 150 hours of training. And on top of the 150, you also have to have a 25-hour ethics and rule training course. So actually, it's 175 hours. It has the same practicum requirement, 40 hours of practicum, but we've added this additional requirement called consultation. And so practicum is you have an experienced person, somebody licensed, watching you, helping you do the administration sessions. Consultation is after the sessions, you're talking to an expert or another licensed facilitator about what the experience was, how it went, how to improve it. You're kind of getting feedback from a colleague or someone with more experience as part of consultation. So there's a difference between Colorado and Oregon. We have an extra kind of requirement for consultation. The good news for Oregon licensees, though, is if you've been practicing in Oregon for a year, you can kind of skip past all that Colorado specific training requirements, and we have reciprocal licensure, which means that you could immediately get licensed in Colorado if you are licensed in Oregon for a year. And I'm going to try not to look a lot at the chat, but I just noticed Mandy's how many hours for consultation? 50 hours of consultation in Colorado. Anyways, I said Laurel's all over it. So I was just saying that there is this ability to get licensed. If you're already licensed in Oregon, you get a license immediately in Colorado. I would have to check this again, but I think you would still need to take that 25-hour ethics and rules course in Colorado, even if you have all the other requirements. And maybe Laurel's saying you don't, so maybe you don't have to take that. But that would be my only open question, if you immediately could get licensed based on an Oregon license. I haven't really helped anybody in that situation. We just started licensing here January 1st, so about a month and a half ago. So yes, happy to be corrected, or anybody wants to chime in with anything, please do. And again, we'll have time for additional feedback and Q&A and interaction at the end. Okay, so another big difference between Oregon and Colorado, maybe the biggest difference, is that facilitators in Oregon, if they have another license, like a mental health or a medical license, they're not supposed to actively practice that other license as part of the facilitation in Oregon. And in Colorado, we did the exact opposite. We said, if you have a secondary license of therapy, mental health, or medical license, and there are actually some limited categories there in Colorado. It doesn't include everything, like a nurse, for example, is not included in that category. But if you have that secondary license in Colorado, you can and actually have to practice your profession as part of the facilitation. So a therapist who's dealing with the participant who's got, mental health issues, PTSD, depression, whatever, would be incorporating their therapeutic practice into the facilitation work in Colorado. So that's a very big difference where you can't do that in Oregon. You have to do it in Colorado. And actually, that brings up another difference, which is we have two classes of facilitation licenses in Colorado. We have a clinical facilitation license, which is for those mental health and medical practitioners. Again, not everybody is included in that. Naturopaths aren't included. Nurses aren't included. Psychologists who are not licensed therapists are not included in those categories. So there are some things that are not part of clinical facilitation, but that's the category in Colorado where you can incorporate your medical or mental health practice into the facilitation. The other license in Colorado is just called an original facilitator license, which is for all other non-medical, non-mental health licensed individuals. So again, that's a difference. In Oregon, there's just one facilitator license. In Colorado, we have two based on those distinctions. I think I won't go into a lot of this. There's probably some minor differences on intake forms and screening, and differences about in Oregon, you can't serve somebody who's had lithium in the last 30 days. But in Colorado, you would just need to consult with an expert and come up with a safety plan to make sure that you can do this safely. So there are some differences in the screening, and but generally prep, administration, well, actually 4 stages: screening, prep, administration, integration. That's all the same in both states. There are some differences in the timing of the administration sessions, and I believe in Oregon it's administration sessions up to 6 hours or until the client is safe to leave. And in Colorado, it's also dependent on the dose. I understand that in Oregon, it depends on the dose. And it's the same in Colorado, but I think the hours aren't the same. We're trying to amend this, but up to 1 gram right now is a 3-hour session in Colorado. They're going to try to reduce a microdose down to as little as an hour or maybe lower, but we haven't done that yet. But right now it's up to 1 gram is 3 hours. 1 gram to 5 grams is 5 hours. So there's a little difference in the number of hours here. I think in Oregon, it does go down as little as 1 hour of supervision if you have a very small dose. The maximum dose is 50 milligrams in Colorado of 5 grams of dried fruiting body. So let's see. I was going to say another difference in Oregon, you had this 2-year residency restriction on ownership. We don't have that in Colorado. It doesn't matter anymore because now in Oregon, you've lifted that residency restriction. But that relates to another thing is in Colorado, we have a limit of 5 licenses per owner. I don't think you have that in Oregon. I'm not sure it's been a big problem in Oregon, but the idea was you couldn't come into Colorado like with cannabis and get 20 healing centers. You'd be limited to 5. And actually the 5 is all licenses together. So if you're going to get a grow and a healing center and a manufacturing license for products, that's 3 licenses right there. So it's not 5 in each category, it's 5 total that any individual can own. So that's a difference. Oh, there you go. Rose correcting me, my friend Joy Tima there. Thank you, Rose. And so maybe that's a similarity. I guess another big difference is in Oregon, you have local opt-out. In Colorado, we got rid of local opt-out. You cannot opt out at the local level. in Colorado, but they can regulate the zoning districts and hours of operation in Colorado. So, some people say in Oregon this hasn't been a major problem other than in isolated locations because most of your major population centers have allowed it and people have access. But, I think it's much better in Colorado without the ability to ban at the local level. But some of the more conservative jurisdictions have done things like try to create distance requirements from schools that mean effectively nobody can be cited there. This would be Colorado Springs or Castle Rock, or Centennial has had challenging provisions of their ordinance. So definitely, if you want to operate in Colorado, you need to pay attention to the local rule. They can't ban, but they could have a very restrictive ordinance. And also, even though licensing has started in Colorado, I would advise people to wait until the local zoning rules are clear. You could apply today, even before the local zoning was done. But if they zone later and say your location wasn't allowed, you're going to be in a fight. Some people believe you would be grandfathered, but you don't get grandfathered unless you have some written permission from a local government. So I just think it's very dangerous to just run out and get licensed today in Colorado. There's only a couple towns that have actually created zoning. So I would make sure you have a local zoning ordinance and that's clear. Your location is allowed. Another big difference between Oregon, I know this is taking longer than I expected here, and so that's fine because plenty of time to talk nitty gritty on Colorado. But big difference would be in Oregon, you don't have an accelerated licensure path like we do in Colorado. So remember I said there's original and clinical facilitators in Colorado. A legacy, let's say a medicine person, shaman, traditional healer, this would be usually, unless they have a license to be a therapist or a doctor, this would be a original facilitator license. So somebody with that legacy practitioner status in Colorado, by the way, if you have the medical or mental health license, you have to apply for the clinical facilitator license. You can't just downgrade yourself, because the point here is for an original facilitator, a non-medical, non-mental health one, if you could show 40 participants with 200 hours or more of facilitation time over 2 years or more in Colorado, you could bypass the training requirements and get automatically licensed in Colorado. Again, you would have to take the 25-hour ethics course. This is called accelerated licensure for legacy traditional practitioners who are not medical or mental health people. So that's a difference. If you're a clinical person in Colorado and you have training, let's say from from what is now a state licensed training organization like Naropa, Intertrek, and you took the class before it was state licensed, you could have the training center validate your past experience as meeting the current requirements, and you might be able to excel. In other words, you don't have to take the course again if your course was with a state approved training organization in Colorado, and there's about 10 of those. So anyways, the point here is that there's some accelerated licensure pathway in Colorado for people with prior training or experience that doesn't exist in Oregon. A couple other quick things, and then I think we'll shift to Colorado, and we're talking about it the whole time here, but in Colorado, we have 2 tiers of licenses for both healing centers and cultivation and manufacturing. So actually for 3 different licenses, we have multiple tiers of license that I don't think you have in Oregon. So what it means in Colorado is you can get a regular healing center license, which allows you to have up to 5 kilograms of dried fruiting body. That's a lot of product, right? So that's like a full-on, that's as much as you could have, and you're operating all the time. You have multiple sessions per week. But you can also get a micro healing center license in Colorado, which is intended for the therapist or practitioner that's only going to have 1 or maybe 2 sessions a week. It basically is a cap of 7.5 grams on hand of dried fruiting body. And again, there's could be equivalents to this for edibles or other products, but for just talking dried fruiting body for a minute. So 7.5 grams means you've got a couple doses on hand. And the difference is it's more expensive to have the full healing center license in Colorado, cheaper to have the micro healing center license. Also, the micro healing center license is it's reduced security and alarm requirements. So it's going to be a little cheaper to have all the security requirements in a micro healing center than a regular healing center. So there's a difference. 2 tiers of healing centers, 2 tiers of cultivation license. You can have a full cultivation license or a micro. The micro, again, it's intended for someone maybe who wants to do a micro healing center and they want to grow their own. And you can just have a small amount of actual dried fruiting body on hand. But all these things, like if you're a micro healing center, if you run out, then you can order more and have it delivered. So a lot of people are going to try the micro healing center license and just replenish supply as they go. And that's a way to reduce costs. And then the other one I mentioned, 3 categories of licenses with multiple tiers, is the manufacturing license. I think most of you guys are assisted therapist folks, so cultivation and manufacturing isn't necessarily your thing. But if you wanted to, in Colorado, you can get a regular manufacturing license, which allows you to make capsules and tea bags and limited products that don't require any kind of heat or extraction. But if you want to do some kind of psilocybin extraction project in Colorado, you have to have the 2nd tier manufacturing license. It's manufacturing with extraction. It's much more expensive. So there's another example of the agency was trying to create options. Depending on what you want to do, you could try to reduce your costs. And I don't think anything like that exists in Oregon yet. So that's a difference. Okay. I'm going to try to shut up in 10 or 15 minutes here. So let me see if there's anything in particular about Colorado I want to highlight here that we kind of haven't talked about. One would be to remember we have more plant medicines in Colorado than you do in Oregon. So right now we're starting the program with psilocybin. However, it is possible we could add mescaline, DMT, and iboga down the road in Colorado. And the gatekeeper here is both the advisory board and the indigenous working group is going to have input on whether these 3 additional psychedelics should be added to our regulated model. And I think we're going to have an interesting discussion. By the way, in Colorado, I think this is the case also in Oregon, we can only have naturally occurring psychedelics. So you can't make synthetic DMT or synthetic ibogaine. Has to be from a plant. And I guess the reason that's important is that some people, for example, say, look, you should never have ayahuasca in a doctor's office with, these kind of rules around it where you can't have a fire and, all the things that people would want to do. And we'll have input from our advisory board and our indigenous working group. And it could be disputed whether some of these other medicines get added. And because we can't have synthetics, I don't want synthetic ayahuasca. I think that's ridiculous, by the way. But like some type of DMT extract from acacia bark, maybe. But you may never see ayahuasca in a regulated setting. Same thing with iboga. It may just be recommended against because, this is something that's threatened in terms of supply in Africa. It's potentially cultural appropriation. I mean, there's a lot of serious issues here. So this is just something to watch. I think in the next year and a half, you'll start to see some debates about what else could be added. But I am hopeful that we will add some additional medicines here in Colorado. and that there'll be additional things to work on in the future. Yeah, I think we're really here to talk about differences between Oregon and Colorado, or similarities, I guess. But, I think there's a debate among some people who see this decriminalization thing in Colorado and say, wow, I could go through all this licensing, or I could just come to Colorado and hold a retreat and share medicine for free and be paid for services, because actually we wrote a provision that says that. The thing I would say is there is a pathway in Colorado to do decriminalized work. However, the agency is looking very negatively at this stuff. And especially if you're a licensed therapist or facilitator or medical provider. By the way, if you were a licensed therapist in Oregon and you wanted to become a clinical facilitator in Colorado to do therapy, you would have to get also a therapy license in Colorado, just to be clear with that. And then once you do that, if you have a facilitator license in Colorado and you think, oh, great, I'll work some in the regulated and maybe some in the decrim, the agency is just showing a lot of hostility to this idea. And maybe in a future conversation, I could run you through some of the disciplinary cases I've done for psychedelic assisted therapists and talk about why it's challenging. So there is a pathway in decriminalization, but it's very complicated, nuanced, and has more risk. If you want less risk, more certainty, for example, in decrim, you cannot advertise the sharing of natural medicine or services provided. So a technical reading of the law would be you can't even have a Facebook ad. Actually, Facebook wouldn't let you have it, but you can't have some social media post saying, ayahuasca retreat in Colorado. The agency has gone after certain people that have done that. But it is something that I talk to a lot of people about. And, if you reach out to me after, we could have a more detailed conversation. What else? I'm not sure. I assume there's continuing education requirements in Oregon, but there definitely are in Colorado. You have to have, I think it's about 20 hours a year of CE. We also have something called a training license in Colorado. Maybe you do have it in Oregon, but the idea in Colorado is that if you meet all the educational requirements, but you haven't done supervision or practicum yet, you can get licensed right away, and you can do the supervision and practicum as soon as possible within the 2-year period of the training license. And the training license allows you to do the facilitation work right away. So even if you haven't finished all your supervision and practicum work, there's also a pathway to licensure in Colorado. Yeah, just giving you a sense of cost here in Colorado. If you wanted to start a healing center, you got the micro healing center license. That's $3,000 for the first year for the application and license. You would also need an owner license for that healing center, even though you're going to be the facilitator. So that's another $750 for the owner license. 800 and something for the facilitator license. So we're at about $4,500 in state licensing fees per year for a facilitator. And then of course you would have to furnish the security and alarms required to run the center in Colorado, get a lease. So just like Oregon, I think we're going to see people start healing centers that they lease out to facilitators. So maybe you don't have to actually build out the healing center all by yourself, but then you're going to be paying a portion of your revenue to a healing center to use the space. I'm almost done here. I think we could have a lively discussion, but I'll go back through some of these questions. But I did want to mention some other requirements in Colorado. I'm not sure if this is part of the Oregon thing. I don't think so. But as part of a healing center application, you will have to submit an environmental, social, and governance plan, ESG plan, which the idea is basically how are you going to give back to something? And there was a lot of fear this would raise a lot of costs, but it turns out I think you just have to pick one thing if you want to have sustainable packaging, you can promise to, buy biodegradable packages and recycle and do something for the environment. And you will be measured against this upon renewal. So it's not like it doesn't matter, but you don't have to have something in all three categories. You just have to pick one. Look, I want people to give back as much as they can, but you don't have to do something for the community, the environment, disadvantaged communities, whatever. You can just pick one thing, but that is a requirement of the application in Colorado. And what else? I think we got most of the main things. I would just say I am not totally familiar with the requirements for all the SOPs in Colorado, but let me show you. It's kind of brain damage here. I'm sorry, in Oregon, I'm not familiar with the SOPs required in Oregon, but I have developed model SOPs for people. And so just take a look just for administration sessions. These are the SOPs. Of course, you're going to need the state model screen forms, which they haven't even finished yet. And I've got an early draft copy. And I'll update that, but you got to have an SOP about the prep session, administration outside, all these things. So this is a lot. And, you just have to, there's rules that reference each of these things. So not plugging my services really, but obviously I'm doing these for people and helping them with it. But I'm just thinking in terms of cost. You got to have application costs, the security costs. You're going to have to spend some decent amount of time on SOP creation, record keeping creation, system to track all the forms that you're going to have to track. And that's why looking at all this, and now I'll shut up, we can open up to some Q&A. It's like many people are just like, this is impossible. Like, how am I going to, So I'm sympathetic, and I think it's a very challenging system. And from what I know of Oregon, if you're a really great facilitator and you have a good community and word of mouth, you're going to be busy and probably be able to make it work. But, my critique I hear about Oregon is that there's a lot of training centers and not a lot of work for all the facilitators. And so I think it is a serious question, like how much are you going to invest in this system that is expensive and complicated? But the attraction is you're much safer in a regulated model, in my opinion, than in the decrim world. So with that, I'll just shut up and we can have a little open dialogue, and happy to answer any questions I can.
Hey, thank you, Sean. That was great. So a few questions that came up in the side chats I'll run through and encourage everyone for right now while we're on recording, if you'd like to ask in the chat, and then we'll answer, and then we'll turn off the recording and open it up. This way no one's name pops up in a recording if that was not what you wanted. So one of the questions is about showing experience in the, your underground work, particularly if it was before the act was passed that allowed for the, for the decrim work. Is there any liability about that essentially somebody admitting that they've been doing work outside of the system to get licensure?
Yeah, so the answer is for those non-clinical facilitators, the only person it's relevant for are non-clinical facilitators in Colorado who say, I want to get accelerated licensure. I have this 200 hours with 40 people over 2 years or more. You absolutely will need to reveal, any evidence you have that you actually did that work. So then people are like, well, how would I prove that? I think what I understand, the agency is actually asking for names and, times of when you did the work. And so I don't know, a calendar or, a agreement you had with somebody, which a lot of people in the decrim unregulated world never had written agreements. So, but they'll take all evidence you have and consider the totality of the circumstance. So for those people, it would be relevant and you would want to disclose it. But For other folks, it's not really relevant because you need to have the 150 hours of training, 40 hours of supervision, 50 hours of practicum, and your decrim or unregulated work will not count towards any of these practicum hours if you're a licensed therapist in Colorado. So there's no need to bring it up. So yeah, there you go.
Thinking in another one on the future plant meds that would be opening up, will there be a distinction between the NN-DMT and 5-MeO DMT?
We just decriminalized and created a pathway for DMT, dimethyltryptamine. So when I'm not a chemist, I'd heard NNM DMT and 5. Of course, I know what 5-MeO DMT is, but my position on that is the only thing illegal in 5-MeO DMT is the DMT. The other molecules are not illegal. So, but this will be part of rulemaking, and the form of DMT, like I said, it's got to be from a naturally occurring source. So I think you can get NN-DMT from naturally occurring sources, and I think it will be subject to rulemaking, and I don't know how it'll go. It'll be a year and a half, 2 years from now.
This may be a little too far out to know. Somebody asked if a BOGO would be limited to a medical facilitator licensure.
I would assume so. Like if a BOGA comes online, I think we're going to see full medicalization with the cardiac team and resuscitation, and it is not going to be the stuff of lineage legacy practitioners that are giving the. Anyways, yes, I think it will be highly regulated, but this is to be determined. And there are serious cultural appropriation and issues around Iboga, and looking back that we included that, and it could somehow hurt people in Gabon and Bwiti people. I don't know if, I'm hopeful that will end up in the regulated model, because I would like to see Colorado a leader in opiate and alcohol addiction recovery, but it's going to be an interesting debate. So I don't know if it's guaranteed. We'll see.
Thank you. And next was on if there'd be discounted rates for either veterans, or Oregon has discounted rates for licensures. Will that be an option for there in Colorado?
I believe there is priority processing of applications in Colorado for veterans, but not a reduction in the license fee. I would have to check that, but I don't believe so. But there is priority processing for those folks.
Excellent. And a clarification, when you're saying the decrim pathway, is that the same as the personal use law?
Yes.
Okay. And finally, do you know anything about how much a liability insurance is required in Colorado?
Yeah, this is a interesting topic here, because we just pull something else up here. Maybe I'm having I'll just say it this way. Go find me on Instagram, in LinkedIn or Facebook. I'm having a whole webinar about insurance and liability coverage, and how to limit your liability in these regulated models. But my understanding, I would love to hear the crowd's reaction, is there was a company giving some policies in Oregon at the beginning. They pulled out of the market in the fall, and they're no longer there. But there are other insurance companies looking at this. And if anybody's going to get an insurance policy, it's going to be a regulated person. But I don't think it's highly available. It's probably ridiculously expensive right now. And so the things you have to do to limit your liability are the proper screening, developing that healthy facilitator participant relationship, following your ethics. And in Colorado, I don't know about Oregon, but I'm going to create a liability waiver form. I don't think it's not permitted in Colorado. And actually, I did this for one Oregon operator too. So the state forms don't waive liability, but I think you should have something in there saying people are assuming the inherent risks of psilocybin. And, it's not your fault you do the best screening you can, somebody could have a negative reaction and they accept that risk. So I think there's things you can do short of insurance to still protect yourself.
Excellent. Thank you. And we touched on this briefly. I mean, if you could talk about again about the difference between the micro healing center and a regular healing center.
And again, I'm always a little bad on these numbers, but I believe the numbers are micro healing center can have 750 milligrams, which is 7.5 grams of dried fruiting body on hand at any time. And so that's a very low limit, a couple doses there. Whereas a full healing center can have 5 kilograms of dried fruiting body. So it's a amount limit that is the difference.
And somebody asked about if there's any way to get an early draft copy of the forms to review.
I don't believe these are easily publicly available. And that's why I hate to do this, but like I am selling SOPs, and along as with a packet with me of SOPs, you can get the current draft forms. I'm trying to get the final ones, and they don't even have it yet. So I have the December version, but it has to be part of a packet of SOPs that you get that with if you reach out to me. And I'll consider case by case if you really are in a tough situation, but it is a valuable thing. And so I normally charge a little bit for that. I did want to say before you were 10 minutes left here, and I'll pop through some of these other questions, but just to make sure people understand, like, yes, I'm doing licensing in Colorado's Prop 122. I'm advising on that decrim personal use space. I also do a lot of work in religious freedom. So this isn't something we've talked about, but I was the lawyer for the Church of the Eagle and Condor, along with other lawyers. And we are the third ever recognized federally ayahuasca church. I'm in federal court right now with the Church of the Celestial Heart, which is probably going to be the fourth ever recognized ayahuasca psychedelic church in America. And so that means at the end of this year, probably my clients represent half of all federally legal psychedelic churches. So I thought a lot about that issue, and that's a whole nother pathway, including for people like who are on this call. Well, what if I just want to do spiritual work under a religious freedom protection and opt out of all this? So that's a whole nother area I advise people on. And then I work with ketamine clinics and just generally people doing psychedelic assisted therapy in a regulated context. So I do licensure defense. Anyways, I just want to make sure people get a sense of the scope of what I do, and they can reach out after today on any of those topics. So yeah, back to some of the questions. Maybe Jason, you want to curate these, or I could pick a few, or
Yeah, one that they thought was and kind of opens up of just a broader concepts would be great to discuss. You know, if a doctor wants to stay in the GCRIM world, can the doctor sit with someone if the patient provides their own mushrooms? I mean, that's covers a lot of kind of ground there, but really good.
Right. Well, that's why I'm glad I just went through the scope of my practice, because see, there's an example of, well, let's see, if the doctor was working in a spiritual practice and could argue they weren't acting as a doctor and they weren't providing medical services, then there's an argument that they can't be disciplined by the medical board for doing spiritual work. But this idea of a doctor sitting with somebody who brings their own, there's just all sorts of issues. If you have a license for a medical or mental health practice, you know, I've seen disciplinary cases where people didn't want to be regulated by the therapy board, so they gave up their therapy license. And later the therapy board came at them and said, hey, you're practicing therapy without a license because you're doing the things a therapist does. So if you're a doctor and you're doing a thing a doctor does, that you would have to look at all the prohibited acts of your Medical Practice Act. And I'm sure somewhere it says you shall not endanger the patient and you can't give them illegal drugs. And, you know, the level of your involvement with them getting the mushrooms, and what are you meeting a standard of care if you're sitting with somebody on a federally illegal drug? It's just the whole point here is people in a licensed profession need to take a lot of care, and we could talk through those issues. And those are the kind of things people do to make their situation better. The patient brings their own. They're only providing harm reduction services. They do an agreement, kind of like when a doctor does coaching or a therapist does coaching in a state when they're not licensed. They do an agreement that says, this is so different than my medical practice or therapy practice that you understand I'm just going to be here to, if you have a medical emergency, I'll call 911. But, each of those issues, like, we would need to spend a good amount of time, and it shows that it's risky to do any of those things. So if you want less risk, you'll just stay in these regulated models. There's a rule in Colorado, you cannot be disciplined for doing what's legal in the regulated model of Natural Medicine Health Act. So if you're a doctor, you could never lose your license from the state for doing psychedelic therapy. That's not the same answer in the decrim world. So there are risks.
I want to thank everybody for attending, and Sean, really appreciate all of your time. And if you'd like to stay for an open Q&A where you can come off mic, please feel free to do so. All the contact information for Pata and for Sean is we'll put into the sidebar. We'd love to answer any questions you guys have at any time. So with that, I will stop the recording.